I don't think you'll get caught in the recording though, so I could be wrong. Anybody in OUA land or that isn't here is annoyed by that crunching. It's not me. I'm the slurping for my drink. Crunching is Christy, don't worry. I'll edit that out. Okay. I know I'm still sitting down, aren't I? Is that all right for just a little while? I'm still not 100%. Quick reminder on pre-contractual statements. So we talked about these 2 weeks ago when we were looking at express terms and how we worked out which terms or which statements made before a contract was entered into get incorporated into the contract itself. So the cases that we looked at in relation to that were JJ Savage, so that's the one about the boat engine, Dick Bentley, which is the one about the Bentley, easy to remember, the one where the expert terms, that more credence is given to an opinion made by an expert, and Van den Eschet, that's the one with the termites. So they're the kinds of things that we look at in determining whether statements made before a contract is entered into are or are not contractual terms. If terms aren't contractual, so another approach to this is thinking about excluding additional terms or those negotiations from the contract. The approach that it's not done till it's all done. Incorporating in the agreement an entire agreement clause that essentially states that nothing that was said by the parties or agreed by the parties is relevant unless it's in the entire agreement, if it's in the final version of the document. And then we've also got the rules, parole evidence rule, and the rules coming out of cases like Escort Court. I'm never going to be able to say that, is it? I'm just going to call it Glengallen Investments, the prawn in fishing investment case, where it's quite clear that a document that's in writing, an agreement that is in writing that supersedes a verbal agreement, supersedes that verbal agreement, wipes it out in its entirety. But the question does arise from time to time of whether a statement that is a key element of the decision to contract, the extent to which it can be incorporated in the contract, and the other part of that is the extent to which an entire agreement or an exclusion clause can wipe it out. And the context I want to look at that in particular is statements that might be misleading or deceptive. So I want to turn our minds to, in particular, Section 18 of the Australian Consumer Law. So, what does an entire agreement clause look like? Here's one I prepared earlier. What am I? Not sure. So, basically, this one's in 4 parts. This agreement constitutes the entire agreement between the parties and supersedes and extinguishes all previous agreements, promises, assurances, warranties, representations, and understandings between them, whether written or oral, relating to its subject matter. So the relating to its subject matter is kind of important because we might have a verbal agreement in relation to the sale and purchase of cups of coffee, but the subject matter of this agreement is the sale and purchase of the whole of the cafe. Okay, so we might have concurrent agreements amongst parties. Then each party acknowledges that in entering into this agreement it doesn't rely on and shall have no remedies in respect of any statement, representation, assurance or warranty, whether made innocently or negligently, that is not set out in this agreement. So thinking about JJ Savage, any warranty or purported warranty that the boat should go at 14 knots with that kind of engine, rather than have a question about whether that is an opinion or an express warranty, an express term of the contract, a clause like this says those kind of statements, they're not specifically referred to in the contract. If the contract doesn't say that the boat will be able to achieve speeds of 14 knots, doesn't matter, it's outski. Each party agrees it shall have no claim for innocent or negligent misrepresentation or negligent misstatement based on any statement in this agreement. It's actually broadening it. So to the extent that a statement in the agreement is a misstatement, the other party, if it's made innocently, the other party has no claim in relation to that. And lastly, nothing in this clause shall limit or exclude any liability for fraud. So, in other words, if it's done dishonestly, you're still liable. So it's not excluding all negligence, but it's excluding innocent misstatement. Pretty standard clause, probably quite well drafted. A little bit hard to tell outside the context whether they're well drafted or not. So that's the kind of clause that we're dealing with here. So can you see that it is a type of exclusion clause? Because it's excluding, purporting to exclude occurrences outside the contract itself. So how do these work with pre-contractual statements? So we've got to think about Section 18 of the Australian Consumer Law here. And remember that liability for misrepresentation can't be avoided by relying on an exclusion clause. That the law says clauses that purport to avoid Section 18 will be void. And there are three reasons for this. Firstly, an exclusion clause in a contract can't break the nexus between the pre-contractual misleading conduct and the conduct that was induced by that contract, the contract that was induced by that conduct. So Section 18 prohibits misleading or deceptive conduct. It's important to recognise that it's the conduct that is prohibited in trade and commerce. It doesn't matter whether you're intended to be misleading or deceptive or not. The question is, was it misleading or deceptive, or was it capable of misleading or deceiving someone? And so that is prohibited. So if we have an exclusion clause that says, doesn't matter if you were misled or deceived beforehand, for the purpose of this contract, the only thing that matters is what's in the contract, then it undoes the benefit that the legislation is trying to achieve. Secondly, an exclusion clause cannot at common law provide protection against fraudulent misrepresentation. So we can just stop there at that point. But lastly, the rule applies to Section 18 of the Australian Consumer Law, and an exclusion clause cannot defeat the operation of Section 18. So the provisions of the law itself, I'm remembering 64, 64A, are the clauses that essentially prevent or state that any attempt to wipe these clauses out will be void. So in fact, the next slide will tell us. So, and in surprising us all, I remembered the clause number correctly. Section 64 provides that a term in any contract, including a collateral contract, which attempts to exclude, restrict or modify the application of all or any of the part of the law that Section 18 sits in, will be void. This is construed strictly. So contractual terms will only be taken to exclude, restrict or modify the application of a provision if they do so expressly or they're just absolutely inconsistent with the provisions. So statutory guarantees, so to state that no guarantee will be given when the statutory guarantees sit inside the law and are a mandatory requirement, absolutely contrary, those kind of provisions will be void. Terms that lead consumers to forego rights that are available under the law will also be void. So any purported waiver will be void. There are some specific prohibitions. So Section 29, 1M, for example, prohibits the making of a false, or misleading representation concerning the existence, exclusion or effect of any condition. So think back to the dry cleaning case. I want to say Causer and Brown, but it might have been the other one, name of which is escaping me right now, when the lady's brought in her wedding dress and she said, "Why do I have to sign this?" And the assistant says, "Oh, it's just in case any of the beads or sequins get damaged, we don't take liability for that." She misrepresented innocently. There was no argument of fraud, but it was an innocent misrepresentation as to what the term meant. Now, in modern day Australia under this law, that would be a breach of that section. So the dry cleaning company would be in breach, because it doesn't matter whether you intend to or not, you can't misrepresent the operation of the law or of the provisions. The other issue that, well, yeah, might not. The clause as described would probably be okay, limiting the liability to very specific things. A term which excludes, restricts or modifies provision in the division may also be found to be unfair. We'll talk about unfair terms as we move forward. Section 64 catches attempts to limit the operation of the division both as to the actual terms of the contract and the remedies that are available to the consumer. So it doesn't provide that an offering term exists only to the extent of the inconsistency, so the offending term I should say. It provides that the terms will be void ab initio, so they will not apply if they contravene the section. So instead, terms are void to the extent that they purport to exclude, restrict or modify the division. I think the best way to illustrate this is to talk about this case. I've just realised I was going to print out the clause for you, but I'm hoping you'll be able to see them on the screen. So this is a case I recommended that you have a look at last week, Nifsan, related to the purchase of a property off the plan in the Gold Coast hinterland back in 2008, 2009, I think. This is actually a picture of the development. I don't know which building we were talking about, but it's one of them. And so Mr. and Mrs. Buskey, I'm assuming Mr. Buskey and his partner, I don't be another, decided they were going to buy or wanted to look at buying one of these buildings off the plan. They went in and they spoke to the sales agent. So this is a fairly large development with a number of different buildings in it, and the developer, Nifsan, had hired or engaged a contract sales agency firm. So basically a firm of real estate agents, had some premises somewhere on the development site, had some fancy models and probably one of those kind of, display apartments that you could go in and see what they look like and walk around. And anyway, the Buskeys really liked the layout of the apartment. They were really keen on it, but they kept saying the thing that really matters to us is the views. We love the Gold Coast hinterland. We want to have these uninterrupted 180-degree views across to the water. And so the sales agent said, look, we can do that for you. In this particular development, construction had started on it. They said, take you up in the one next door and we'll take you up to the same level that they were building. Have a look at one of these apartments. Basically, what you're going to get is the same as this, only move it 100 metres to the right or the left or north or south or whatever she said. I don't know who they were. So they got a pretty good idea of what they thought the views would look like. So they went back down, and as you all know, I'm sure, property contracts are very highly regulated. So they get their equivalent in Queensland of Section 32. So a statement that sets out all of the rules that relate to the body corporate and issues with defects and what happens with the warranties from the builder and all of that stuff. Big, thick document, no doubt. How much the rates are going to be, and so they've got all of that. They sit down and spend some time picking tiles for the bathroom and paint colours for the walls and specifying what kind of dishwasher they're going to have. And so they have a whole list of special conditions that have those kind of things that aren't unusual. Nowhere in the contract does it mention the views. They go and take the contract to the lawyer, as many people do. They ask the lawyer to do the conveyancing for them. The lawyer does that. Contract includes this provision, which is going to be quite hard for you to read, I think. I should have printed it out for you because I do want you to think about it. I'm going to do that boring thing of actually reading it out to just make sure you can see it. So here the Buskeys are the buyer and the seller is Nifsan, and the agent, don't know what they were called, but is the real estate firm. So actually I'll read it that way. So the Buskeys acknowledge and agree that no representations of the sales agent or Nifsan was supplied or made to the buyer, to the Buskeys, with the intention or knowledge that it would be relied upon by the Buskeys. No representations have in fact been relied upon by the Buskeys unless they're specifically contained in the contract or the disclosure statement. So the disclosure statement is the section that would contain all of the special conditions, for example, branded dishwasher and oven that they were using, kind of carpets, tiles, that kind of thing. Before the Buskeys entered into this contract, they satisfied themselves from their own independent inquiries as to the value of the property being purchased. The Buskeys have relied on their own judgment in purchasing the property on the terms contained in this contract. The terms of this contract and the disclosure statement are the entire agreement between the Buskeys and Nifsan, despite any representations before the Buskeys signed this contract. To the extent that there were any representations before the Buskeys signed the contract, the terms of this contract supersede them. That's a nice one, I quite like that. Without limitation, no representations have been given that the property is or will remain fit, suitable or adequate for all or any of the purposes that the Buskeys wish to use the property for. And lastly, to the maximum extent permitted by law, all representations or provisions implied by law relating to fitness, suitability or adequacy of the property do not apply to this contract or the property. So you know what the problem is. Oh, you don't know what the problem is. That's the clause. Turns out, unbeknownst to the sales agent, and in fact because the developer had not told the sales agent, work had already started on a new block of flats. And that property was going to be built right in front of the building that the Buskeys were building in. And this new block or this new development would essentially block out their view entirely. So the Buskeys, once they realised that was happening, decided they didn't want to complete the contract and they wanted their money back. So the question before the court, now this is just a single judge Supreme Court of Queensland case. It's not particularly high up, but I think it's an excellent illustration of how these things work, and I think it's a good because it's actually, I think that's a great clause. I think there are lots of things to be admired in the drafting of that clause. I think Mr. and Mrs. Buskey could understand it if they turned their minds to it. We don't know whether they did or not. I think it's pretty clear. You might not agree with me. We can talk that through, that's fine. But the question before the court was, does that exclude prior representations in relation to the views? Was the effective promise or the representation that was made by the sales agent innocently that the views from the apartment they're building for you will look like this, just move it over a little bit to the right, which turn out to be an untrue statement, so a misrepresentation, was that a term of the contract sufficient to allow, I mean, you don't need to think about damages and termination now, you can do that later, but let's assume sufficient for them to terminate or at least get damages. Where do we want to start? Why don't we get some arguments here for Nifsan? Oh no, actually we shouldn't do it. We'll do a plaintiff first. That's the way that it should work. So the plaintiff, ladies, do you want to start representing the plaintiff? Some arguments for why you think this clause, I shouldn't listen to this clause. I shouldn't read this clause. I'm suddenly become a Supreme Court judge. Can't you tell from the hair? Oh, you're on the other side, are you? Oh, you're on the agent. I'll bring you in a minute then. Plaintiff. Oh, there you are. I'm so sorry. Plaintiff. All right. Tell me, why shouldn't this clause apply to you?
Because this clause seeks to get rid of statutory right to not be misled. Yeah.
I genuinely thought I'd put them the other way around. Okay, so tell me what that means. Please advise the court.
Our client would not have entered into the contract if that misrepresentation had existed. So these clauses here exclude the statute of misleading conduct.
Okay, so you've directed the court to section 18 of the Australian Consumer Law. So, and you're saying that the statements that were made by the agent were misleading or deceptive, and they're statements that induced the contract, and presumably your argument then extends to looking at section 64, which says that we can't exclude or limit the operation of the statute. So we have these words at the end, to the maximum extent permitted by law. It contemplates the application of the law. Otherwise, developer, are you acting for the agent? Not developer, what have you got to say about this? Why should I hear this? That all makes sense to me.
Is it the developer or the sales? I think what they said.
Really, I'm very sorry if I've mucked that up. I feel like I'm better than I was last week, but it's clearly not the case. I genuinely thought you guys were looking after the developer and that I'd asked you guys to look after the buyer, and I've done something completely the opposite. So, or you've just confused me. So, the agent. Well, tell us from the agent's point of view. The agent is not even a party to these proceedings, but I'm going to listen. Why should I listen to the agent? Why is the agent a party to these proceedings?
It's the agent that gave us the misrepresentation.
But they were provided with a misrepresentation as well.
So think about, well, what's an agent?
The agent is working on behalf of...
Yeah, the agent is the voice of the company here. So they were a separate entity, but they were acting as a disclosed agent for the principal. So the words that were said by the agent were said on behalf of the principal. The contract that was put in front of the buyer was put in front of the buyer by the agent for the principal, for the developer. And then the developer would go back and sign it later, but that's what the agent's doing. Just like the girl in the dry cleaning shop is acting, she's an employee, she's acting as an agent, as the voice of the dry cleaner. The parking attendant is the arms and legs of the Sydney City Council.
So you nearly go, we nearly change it to deceptive and misleading, because the agent should have been aware of the future development going on in the front and warned us of the view being blocked.
Well, he wasn't aware of it.
And
So-
the agent is the voice of the developer, you just told me.
Yeah.
So the developer's aware of it. So the developer should have told the agent, that's not for me to.
So you're essentially arguing that the statement that you got via the agent was misleading and deceptive. But does it matter? Does it matter whether the agent knew or didn't know? Does it matter if the developer didn't even know?
Are you talking about the prior evidence or?
Developer knew.
Well, the responsibility lies in the buyer to ensure that they actually follow.
But what if they didn't lie? It's completely innocent misrepresentation. The humans involved just didn't know.
Because the development could have been 3 stories.
Could have been, doesn't matter.
And I'm a
They
client,
just
I've
didn't
still got
know.
a view.
Well, we also think that.
And I talked to you guys about this along the way. Does it matter? So the provision, section 18, we can bring the words up. No, it doesn't matter. There's no element of intention. The question is not, did you intend to mislead or deceive? The question is, did you mislead or deceive? Or was it possible that somebody could be misled or deceived? Doesn't matter whether you did it on purpose or not. What matters is whether there was misleading or deceptive conduct. And so I've completely messed up playing this game to get you to fight with each other. I've been variously trumped by obviously not paying enough attention to who I was asking to do what, and also the fact that people have read the case, which is a very lovely thing. I shouldn't demonstrate my surprise that happens, but it doesn't always happen. So essentially what happened in this case is that the Buskeys were successful. So now there's a lot of discussion in the case about valuation, but at the end of the day, this clause did not protect the developer because the statements about the view were pre-contract conduct that was brought within the 4 walls of the contract. So even though they weren't made directly by the developer, that doesn't matter. A developer is a company anyway. It's never going to speak directly. It's going to speak through its agents or its employees or its officers. That makes no particular difference.
That's a bit harsh in that, so what in essence the court is saying is that your view can't be built out.
No, what the court is saying is that if you're going to make promises to people before they enter into a contract that turn out to be untrue, then you'll be held accountable for those promises.
But they were true at the time they were viewing. So that was the view. That's my view I'm seeing. There's no building in front of me, but that's the view.
They were true, but work had already started on the next building that they intended to have blocked that view.
So at what point?
So now there's also evidence in relation to that. At the time that those representations were made, the developer, the agent didn't.
Yeah.
And in fact, there was evidence given that the developer withheld information about its future plans from the sales agents, which is actually not that unusual because they want to incentivise them to sell all of the units in one building before they sell the other. Because there's always in any of these buildings going to be units that are easier to sell than others, you know, the ones with the views or the ones closest to the swimming pool or furthest away from the swimming pool or whatever it is. So they want to sell one lot of stock before they commit to starting building on the next lot of stock.
It's like the insurance argument, though, is that I'm purchasing a property, I look down and there's a dirty, great big foundation hole. I've got to do due diligence. And so I've got to go to council or do whatever to see what height that building is. Like, there's an onus.
Well, one might argue that if they'd lost, their next point of call might have been to sue their solicitor as well for telling them their contract was all right when it clearly omitted something that was clearly very important to them. You know, there's, at the end of the day, disputes, every court action that we look at is a failed relationship.
But And then you come back to this though, the whole thing about property is you buy your view. So for you to expect to have a view 4 rows back, you've got rocks in your head. If you want ocean frontage, you've got to buy ocean frontage. You can't buy an ocean frontage 4 rows back and say,
This is what, well, that's what they did and they won.
wow, that's not right.
So I guess the point for this is that we've gone through all of these provisions. A lot of us rely very heavily as practitioners on drafting exclusion clauses. I think that's a pretty good one. I mean, it had some grammatical errors in it. You might have noticed the little sick in the statement of it. Where has it gone?
I would have thought G would have sunk.
Gee, without limitation, no representations have been given that the property user will remain fit, suitable or adequate. But the point here is that that is seeking to exclude the operation of the other provision, the provision that actually was affected by Section 18. So the promise that they would have uninterrupted views.
When I read that I thought that one is for being built out. Your views going.
Well, because that's the purpose for which they'd said they wanted uninterrupted views. Oh, I think it's a good clause. I agree with you. Be interesting to see what had happened if it had gone up a little bit higher, because they're pretty blatant facts. You know, this is also not a low-cost investment. Like, we're not talking about somebody being misled or deceived entering into a telephone contract or something like that. They're talking about large amounts of money, and they're being advised. They've got legal advice, but we came out with this very consumer-oriented process, and that's why I have these kind of provisions for thinking about what this means. I've used this slide in some training that I've done internally for an organisation as well, and I'm just sharing it here. I mean, at the end of the day, here the court found that the clause couldn't change the fact that the purchasers had relied upon the statement that induced them into entering into the contract in the first place. So putting something in the small print doesn't change the nature of the relationship, the agreement. So, and I guess what we need to think about as transactional lawyers, if that's what we're going to be, is to make sure that we understand when we're documenting the agreement what in fact was said and promised during those pre-contractual negotiations. Really asking our client what's important to you. Spending that time to ask, why did you pick this one? What is it about it that matters to you? Do you realise that, are you really sure that everything that matters to you is in the special conditions? And I know the Buskey's won at the end of the day, but we don't want to be relying on the fact that our clients can win these cases. We don't want them to get involved in these disputes at all.
Well, they would have been better to give back the deposit and start. This is the developer. These lots or appeal it. You're either going to run.
Well, I don't know whether this was appealed or not. I should go and have a look actually, because it wouldn't surprise me if it was appealed and then settled. I don't know.
Do you think like, I guess the balance of power sort of thing, let's say if it was another developer who bought like everything, like their whole apartment complex, and then you'd say, well, they have the resources to go and do their due diligence properly. They should have seen that there's another building coming up, and therefore the judgment would be different. But whereas this is just like mum and dad.
Well, but the thing is, the facts would have been different too. So another developer isn't going to buy the whole building on the basis that the penthouse on level 5 has got uninterrupted views. Like, so the point here, sorry? No, it wasn't appealed, okay. Well, it would be in there if it was appealed. Or if the papers were filed. I think, well, they might only have decisions, not sure. In the litigation history. The point of this case, like all of these cases, it's not so much to work out what the wrongs and the rights are, but to illustrate the point. Section 52, the old Section 52 of the Trade Practices Act, Section 18 of the Australian Consumer Law is the single most litigated piece of legislation in Australian history. And the reason for that is it helps you out in a sticky situation in a whole lot of ways. It's the closest thing that we have to a consistent, are you behaving fairly? So what does it mean for us? Actually, I'm going to ask you this question. I've got 4 statements on this page. And I think one of them is untrue, but that the others are not. Have a think about that. So a pre-contractual statement that is not reflected in the terms of a contract can nonetheless be misleading or deceptive and affecting the validity of a contract. Any term of a consumer contract that purports to exclude, restrict or modify any of the rights conferred by or the liabilities imposed by the consumer guarantees, or which has that effect, is void. Exclusion clauses continue to have an important role to play in consumer contracts in Australia. And in consumer contracts, even exception clauses that have been properly notified have become terms of the contract and on their true construction are enforceable, will now be void and unenforceable. One of those statements is untrue. Last one, why?
Because if that's all true, that clause has been discussed and properly incorporated into the contract, so that both parties should know about it. It should be clear. Yeah.
So in consumer contracts, even exception clauses that have been properly notified have become terms of the contract and on their true construction are enforceable, will be now unenforceable. In all cases.
Not in all cases.
No.
That's right.
So it could be untrue in the kind of case of Nifsan and Buskey, for example. So it had all of those things, but because there was a misleading or deceptive statement made prior. But in a B2B context, I would argue that that would remain true.
So bottom left.
Bottom left. Yep. Any particular reason why?
I was saying before, it, the statute covers all of the
Yeah.
exclusion clause.
And we're talking here about consumer contracts. Yeah, absolutely, she says. So, absolutely. So exclusion clauses will continue to have a role in business-to-business contracts, but they won't always work. I mean, the kind of issue that Jono just raised in relation to the bottom one will mean that they won't always be void. They won't always be enforceable either. So we can end up, we've got to take in a broader context into account. But for consumer contracts, I think we can think exclusion clauses are pretty much of very limited value anymore.
I'm seeing it very simply that if you had a meeting of the minds and made that agreement that's brought you into the contract, you can't then have a clause to say the agreement that we made is now.
Well, actually, I think, Sarah, you raise a really excellent point here. If there's a true meeting of the minds, then the exclusion clause will only be in there if it reflects that meeting of the minds. And then it's up to the parties to make sure that the document reflects what it is they've agreed. But if there's a meeting of the minds and then it's documented in a way that doesn't reflect that, the parole evidence rule steps in and it makes it very hard, absent some other exclusion, to bring in evidence of what the meeting of the minds actually achieved. So they're only very limited, sorry, now I've got the hiccups, this is ridiculous. There are only very limited circumstances in which you can bring in evidence of the drafting or the negotiations or the correspondence because of the way the parole evidence rule works. So again, our job as transactional lawyers is to make sure that the verb is matched by the noun. Our job is the noun, the agreement, and it's to document the arrangement itself. So we've got a little bit of time yet. I want to talk really briefly about unfair contracts.